listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee, and with me this time is Paul Doroshenko, and we matched. Did we coordinate that this morning?
We did not coordinate that.
I texted you, wear blue for the podcast.
I often wear blue.
Yeah, I
wear
know.
blue many days. So do you.
Yeah,
It
well,
was a good color.
you know, it's the thing about suits, right? Like, you buy a suit, a lot of them don't come in fun colors, and then you have to wear a suit because you have to go to court.
You have a lot of suits in fun colors.
Yeah, I know, but I don't wear them to Supreme Court for...
No, you wear them to provincial court, though.
Yeah.
Because the judges feel so forgiving in provincial court.
It's not that they feel forgiving, it's that they're not so uppity.
I was in
Provincial court is a place for the people.
Supreme Court yesterday, and the judge was not uppity at all. He was lovely and just very forgiving of my foibles.
I think the days of an overly formal Supreme Court are coming to an end.
I like to think that, I used to, when I started practicing, whenever I would cite a case, I would on the record give the citation of it. And now here I am. Tab 3 is the this case. Tab 4 is the this case, given one name from the case, and nobody's batting an eye. So I like to think
Wait. Oh, carry on. But
I like to think that I mean, it's different if it's a trial and you've got a room full of people as opposed to a chambers application. But I like to think some of that formality that is ridiculous is falling away.
well, I have to ask you
Yeah.
an important question.
Yeah.
When you say the name of a criminal case, what do you say?
I say Regina and, or now I have to say Rex and, if it's a decision in the last few years.
I feel rage inside my soul. Irrational rage inside my soul when people say RV Singh. That's not.
Well, I also feel that same rage when people say versus.
Yeah. It's like it's not.
R versus Jones.
It's not correct. First of all, and second of all, like, what are we like all going on a camping trip? Where's the RV coming from?
Right.
It just sounds stupid.
I mean, in law school, they taught us in like the first week, this is what you're supposed to say, Regina and. The V is a and. We're all friendly together. We're not a versus. The U.S. can have their versus all they want. This is not the way that it is in Canada. And I was like, yeah, okay, fine with me. I'm good with that. I much prefer it to be collegial.
Yeah. So many lawyers these days are all RV lawyers.
Yeah, RV lawyers, yeah.
We should send out a message to the office to make sure no one's embarrassing us by anything that.
We probably should, yeah, and reflect on us. You've got students and things like that. We used to spend more time with students. Now it's because of video conferencing and all of that, it's a different thing. This morning, I was on the Mike Smith show talking about the scooter use and people now advocating for like more dedicated scooter bike lanes as a result of the fact that there's more scooters. And I think it's inevitable.
And more accidents.
And all of these, especially it always happens in June that the bike lobby is out pushing for more bike lanes. And that's the time of the year to push it. Don't push for it in December when there's nobody in the bike lane. But in any event, I realized I'm not an RV lawyer, but I might end up being a scooter lawyer after years and years of practice.
Oh my God. The marketing opportunity for that, Paul, like you could advertise yourself as a scooter lawyer and you could do like maybe a stylized scooter from the Muppets. You probably wouldn't get sued by Disney for that.
And just think of the scooter. Just think of the window of opportunity to earn huge amounts of money from the scooter riders,
Or
notoriously
people-
known to be people with deep pockets.
or the people the scooter riders hit.
Well,
Because you can sue the scooter riders.
Yes, you can sue the scooter riders because there isn't insurance. I should have pointed that out today on that radio interview. That would have been a very good point to make. Scooting.
For you.
Yeah.
After the
Sad.
fact.
Yeah. Well,
It's too late.
maybe next week you can be on. Well, it's somebody that apparently the North Vancouver police said they ticketed somebody's parents.
Yeah.
When they,
Yeah.
and,
That's what we talked about on the podcast last week, me and myself and I.
oh, okay.
Yeah.
So, well, I missed your podcast last week. I didn't hear it. The Lone Soul podcast.
Yeah.
I was on the road delivering alcohol for our jointly owned distillery, and probably my last delivery trip.
Let's talk about RV Raffia.
RV.
Let's talk about the Raffia case. Do you remember this case?
No.
So this was the Ontario court case that found that the term reasonable excuse in the criminal code for refusing to comply with a demand does no longer puts the burden on the accused to raise the reasonable excuse,
Yes.
because the um to prove it on a balance of probabilities, because the criminal code was amended to remove the provision that actually said that it was the burden was on the accused on a balance of probabilities, because there were some cases out of the probation breach regime that had found that that was unconstitutional. So Parliament amended the law, and now it is only to raise an air of reality to the issue of reasonable excuse.
But you can raise that error of reality without putting your client on the witness stand. You can raise the error of reality in many different ways.
You could,
There's no limit to what
yes.
potentially
I
could
mean,
be evidence.
reasonable excuse is a mixed question of fact and law, so yes.
So
In any event, so Raffia was appealed,
yes, no surprise there.
and very interesting thing happened in the appeal, because for the criminal law practitioners and academics out there, the most interesting part of Raffia was the reasonable excuse analysis.
Yes.
But the appeal doesn't even deal with it.
No.
Yeah. So,
Different direction.
like, we talked about the case, but we never really talked about what happened. It was actually serious charges, just like impaired bodily, refusal in circumstances of bodily harm, failing to remain at the scene of an accident causing bodily harm. He ended up being convicted of the impaired and leaving the scene and dangerous.
Yeah.
And he got 15 months in jail.
Hmm.
He'd also made a Jordan argument, because it took 30 months and 21 days for his superior court trial, which
Jeff.
not.
Yeah, Jess. Well, it's a pretty serious one too, so it didn't succeed on the Jordan argument.
Yeah, and the court initially rejected the Jordan argument on the basis of the fact that it was a complex case. And then there was a statement that he made that was admitted, and he argued that there was like an improper sort of quid pro quo that impugned voluntariness. And then there was like a jury charge where he attacked it on the basis of the omission of an abandonment defense, the instruction on mens rea for refusal, the instruction on causation, the after the fact conduct instruction, the omission of self-defense from being put before the jury.
Oh,
And
so complicating the complex case.
yeah, complicating the complex case. And so he appeals because he's the one, obviously, that's found guilty. And the Crown raises their own issue, asking the court to correct the legal error in the decision on the burden of proof on reasonable excuse, which, of course, the Crown couldn't otherwise attack on appeal.
I'm intrigued.
So the Ontario Court of Appeal pretty much rejects every single one of Mr. Raffia's grounds of appeal, basically finding, yes, the case was complex, which, as I just described it, you're kind of like, yeah. It found that the voluntariness analysis was correct. The court had not left self-defense with the jury, but by leaving abandonment with the jury and necessity with the jury, there was enough before the jury to, like, imply self-defense as well, that self-defense was wrapped up in necessity, because if you're leaving out of necessity, you're leaving out of self-defense. And the mens rea instruction was fine because subjective intent was canvassed in the charge. So basically, like, every single argument gets rejected. None of them are particularly interesting to driving law, but if you're into jury charge cases, you might like the case. But as I said, the court is like, yeah, we're not going to touch the reasonable excuse issue. They declined to decide it. And that's the weirdest part about the case, because again, the most important thing that comes from the Raffia case is not any of those jury charge things or the analysis of anything. It is the reasonable excuse question. And the court refused to weigh in it for 3 reasons. It said, first, that it's not its practice to decide issues that have no significance to the outcome of the appeal, except for the significance to the legal community as a whole.
Well, except that I could find 1,000 examples of where they do that, like
Yeah.
courts of appeal in this country.
Yeah. Yeah. Then
I'd go on about something that wasn't even argued in the case.
yeah.
Like counsel wasn't even arguing, that
Yeah.
nobody and will pontificate about it. And
And I guess they determined that because he was acquitted on the refusal, not just on the reasonable excuse basis, but on other reasons as well, it didn't matter whether or not the analysis was wrong. And then it said also that it couldn't properly resolve the issue on the record without submissions from Mr. Raffia, who had no stake in arguing it because it wasn't going to affect the outcome. Which interesting tactical decision to be like, "No, I'm not gonna argue this because it doesn't affect me and it's moot." And they're like, "Yeah, we're not gonna hear it if there's not gonna be submissions from a party affected by it."
government lawyer wants it. He doesn't care.
Yeah.
They want it just for the sake of having a chat.
And
Okay, all right. I'm starting to agree with the court.
the Crown started to suggest, well, if this happens, if you don't hear the case court of appeal, then the case is gonna become evasive of review. And it's just gonna be like an authority that's applied everywhere because it's a superior court authority, and that's gonna there's gonna be no way to appeal it. And the Court of Appeal's like,
No.
other judges can be appealed. They can follow it, and then the other judges can be appealed for following a case that's wrong.
Exactly.
Mm.
Well, I mean, we have decisions from our court of appeal where they went off on a tangent, and that will never be corrected, right?
Yes.
Unless you can persuade our court of appeal to change its mind,
But don't worry, Paul.
which is never.
The Court of Appeal did throw the Crown a bone.
Did they?
Yeah, they were like, but just all of this is to say, just to be clear, we're not saying the trial judge was correct. We're just not saying that the trial judge wasn't either.
Well, that's not throwing a bone.
Well, it's
that's
kind of
meaningless.
implying that they might have overturned it. I don't know.
No.
Anyway,
All right, so there we are.
yep,
The machinations of the courts
that's what
in our
happened in
country.
Raffia. No,
Very often hard to reconcile with everything else.
yes. We also received a very interesting study that was given to us.
Yeah, and I am looking forward to contacting the people who conducted the study.
Yeah.
So I have not digested it, but this is directly relevant to our role as
Weirdly directly relevant to some things that specifically we're dealing with right now.
yes.
So basically, the study is called Exploratory Research. Is Forensic Science a Cause of Miscarriage of Justice in Canada? And it's from Forensic Science International, Synergy. And the study looks at a number of wrongful convictions to analyze the role that forensic science played in those wrongful convictions.
Now, lots of context required here. There has been in the last few years huge revelations in the in a apparently an ongoing practice among many people in the scientific community of producing bullshit science, not backed up, not justified, for the sake of producing science, and a lot of it is garbage. And it is deeply painful for me as a person who believes in the scientific method, believes in evidence, wants to be able to establish my understanding of the world and confidently speak to others about what can reasonably be thought of as reliable, to feature and factor in your understanding of the world. But what we are seeing is a huge discoveries that so much science that has been published is absolute bullshit. And it happens if it happens generally in the world, it also happens in the realm of criminal law. On top of that, Kyla and I have been monitoring all of these lab scandals in the US where people are faking things. The lab's not reliable. The evidence is been manufactured. And we sit here in Canada and go, oh, And we just assume it doesn't happen here
Yeah.
because we just have confidence in the RCMP.
Well, our legal system operates in such a way that it presumes it doesn't happen here. Like, you can't cross-examine an analyst. You have to apply, and then in order to apply, you have to show why you should, but you can't get the records to show why you should because you can't get them with the disclosure without applying for the disclosure, and you can't get the disclosure through the application for disclosure unless you show a basis to get it, but you don't have a basis to get it because you don't have the evidence to show the basis of the problem.
All you get is a document. One document when there's been a 100 documents prepared.
Scout's honor.
Scout's honor. And we operate on that. And not just do we operate on that, our courts are just content with that. Like when we go in to argue that we should be able to get that disclosure, we've got, well, it's never been provided before. Why should you provide it now? This is the police. Why would they do anything wrong? Just like it's just this assumption. And then you see all the lies from the labs in the States where they get this information. And then you see that the science, so much of it is fabricated. And we have been able to identify fabricated science in our own realm, only because we're a little bit cynical about it maybe, or because sometimes you can see it, like you can see it in the science that it's designed to get to a result. Undermines your whole confidence in the justice system. In any event, I'm sorry, that was a long lecture to get to what Kyle is going to explain about this study.
Yeah, so they reviewed 92 wrongful convictions, and they found that roughly a third of them, the reason for the wrongful conviction had to do with some sort of forensic science. And so there were like 30 cases basically that involved forensic science, and of those 30, contrary to sort of what your rant was just about, 97% of them didn't involve problems with the lab analysis. 97% of them were instead misrepresentation by the lab staff, the forensic experts, on what the results actually mean. Like going from saying this person's DNA was located here to this person's DNA being located here means they were here at this date and time, which,
Does not, but
yeah.
They want you to jump to that conclusion because they're there for the prosecution.
Yeah. There were 2 cases that they found in their review that did relate to bad forensic science and like the actual bad analysis, and both of them were involved in the mother risk case, which of course was that faked drug results to try and take people's children away from them scandal that was going on. And so the paper identifies sort of this notion called like a hierarchy of propositions, that essentially when you make the proposition that a fingerprint is there or DNA is there, that's one thing, but then you're making the higher propositions in the hierarchy from it. And not only is there the seemingly the problem that these experts are coming to court and actually testifying to propositions that are outside the scope of what the forensic science actually demonstrates, but that people are more likely to leap to those conclusions too because of this, they call it like CSI effect, right? This effect that people have more trust in forensic science because we see it on TV, right? You watch Forensic Files, you watch CSI, you watch, I don't know what other shows happen now, but
But they're popular shows.
Yeah.
That address forensic science and make it look reliable, sexy, practically magically correct.
Yes. And so while we do have like the Mohan standard for the admissibility of expert evidence, the admissibility gatekeeping effect, the study concludes, that we have doesn't solve the problem of overstatement of what a scientific result actually means in terms of what conclusions can be drawn from it in the evidence, much less what can be proven beyond a reasonable doubt. And so the authors of the study are basically careful to say that it's an exploration at this point. But I think there is like a good basis in this analysis to show that there is a problem with forensic science leading to miscarriages of justice. Now, what does this have to do with driving law? It's all forensic science.
Yes.
Every breath test is forensic science. Every blood test, urine test, it's all forensic science. I mean, I guess a DRE isn't.
Well, we
DRE
can
is junk
identify
science.
just that you can pick any one of those police training manuals and you can find junk science in there.
Yep.
You can find things that are put down as assurances that have never been studied, never been tested, just somebody's theory. There is
Tharp's equation.
remember, you can't see the breath, right? It's coming from the person's expelled from their body, but you don't know the source. You don't know if there's a laceration in their um, throat that might be affecting it or something like that. You don't know. You don't know if it's alcohol that's like deeply saturated in the mucus of the lung tissue. You don't know. And then you don't know all of those things that are maybe functioning in that device. You hope it's doing it correctly, but it doesn't do a standard test. And even when they used to do a standard test with the BAC Data Master with a separate jar on the back, we discovered that sometimes it would pull from the standard when the person was providing a sample.
Yeah.
So, like, the partition ratio, effective temperature, actual source of where the breath is coming from,
Barometric pressure.
elimination, absorption, changing, shifting, blood to breath ratio, all of these things not really studied.
Body temperature.
Body temperature, quasi-studied, right? And every once in a while, you'll see somebody who will mention, well, this isn't really studied well yet. But, we're just going to continue to operate under this assumptions.
It's fine if we have some wrongful convictions. It's all in the name of public safety, Paul.
Well, that's the thing. And what strikes me is I think, okay, all right. Every once in a while, they unearth that a certain number of people are wrongly convicted because forensic science afterward proves that they were innocent. And what about the situation where there's no forensic science to prove that they were innocent, right? How many wrongful convictions are there because of that? And then take it a step further. Think of like the balance of probabilities cases. You've got all sorts of things that are relying on forensic science or not. And if we're wrong on this many that apply it beyond a reasonable doubt standard, how many are the courts wrong about when it's a balance of probability standard? Like, it really does make it feel like it is slightly above a flip of the coin.
Well, that's depressing. I
Well,
guess we'll have
especially when this is like where we, plod the waters, right?
Yeah. Well, I guess we'll have to lighten the mood with
The ridiculous driver of the week.
Good ridiculous driver, though.
ridiculous driver. It's so funny. It's a great video on TikTok. Was it where TikTok where?
Yeah,
Yeah.
yeah, I sent it to you. I resent it back to you. If you can look in your TikTok if you want to find it.
So a guy's pulled over by the police for using his cell phone, and he's waiting to get his ticket, I guess.
And he tells the police officer, "Here, take my phone. Take my phone. Just take it." And the officer's like,
I don't want your phone.
I'm just going to give you a ticket here. That's all. We'll be done here in a minute." Professional, very professional officer. And then
the officer walks away, and you can see on the camera the phone goes flying out the passenger window.
lands on the grass, bounces. And the officer's like, "What?"
Did you just throw your phone out the window? He's like, I don't want it anymore. This is too much trouble. Yeah. And the officer's like, are you okay? He's like, it's my choice. It's a free country. I'm allowed to not want my phone. I'm allowed to get rid of it. Which is the most extreme, weird reaction.
Which brings me back to something that I like to point out to adjudicators, to courts, that people don't always behave perfectly when they're dealing with the police. It is a very unusual circumstance for them, and they're often a little bit freaked out, and they are nervous, and they don't maintain their perfect character. And neither do police officers either maintain their perfect character, or lawyers, or anybody else under extreme pressure. I would say,
What are you talking about? I always maintain my perfect character under extreme pressure. I'm so pleasant to be around when I've got 3 trials in a week.
our soccer team maintained their character under extreme pressure and came out with a 6-0 victory yesterday.
They're
So
handsomely paid.
that's true, but handsomely paid to maintain their character. Anyway, yes, you don't always maintain your character when you've got a heavy trial schedule. Neither do I.
No, you don't need. Where do you think
I'm
I learned
certain.
from?
I'm certain I do. It's only you telling me different that
Uh.
leads me to conclude that maybe I'm wrong about that.
All right. Well, that's our podcast. If you threw your phone out the window after getting a distracted driving ticket and realized you didn't want to dispute the phone, you wanted to dispute the ticket, or you have some other driving law related issue, you can find us online at vancouvercriminallaw.com or give us a call at 604-685-8889 and tune in next week for another exciting episode of Driving Law.
Or scooter law.